It's time for a California tenant and California landlord law update for 2022. We're going to run through some important new laws starting this year, and we're going to do a quick brush up on some that you may have missed because there was a pandemic going on. Hey there. Christian Walsh, real estate agent with Wire Associates. We've been helping tenants and landlords and buyers and sellers stay informed during these crazy days in California and beyond. And it's time to discuss the new laws for 2022 that California landlords and tenants need to know. But first off, this is not meant to be legal advice. As we always say, we can't give tax or legal advice, but for the most honest and up-to-date real estate advice, subscribe to this channel. The purpose of this is to cover some laws for 2022 and some that you may have missed as a California landlord or tenant. And from there, do your own research. We're going to give you links so you can read the respective bills and then reach out to a legal professional for guidance. But the first important thing is to actually know the laws that are out there. Know that there are laws affecting you. So that's the purpose of this video, not meant to be legal advice. And one more important point, these are statewide laws. So they cover all of the state of California. Bear in mind that there are local regulations as well, potentially in your area, and maybe some that are brand new. So make sure you do research into your local area for any regulations. For example, in the city of Santa Ana, they just implemented more strict rent control and just cause eviction standards. And it's important that all landlords use the appropriate paperwork in Santa Ana. And we've done a video about this. Make sure you check your local area for anything that you may need to do. So if you're ready to dive into 2022 laws and some before then, hit that like button and let's get started. There may have been a few laws you missed because of things like a pandemic and all the craziness going on. So we're going to run through a few that you need to be caught up on as a California landlord or California tenant. And then we'll go through a few exclusively for 2022. And this first one is a big one. This is a disclosure for AB 1482, which is the Tenant Protection Act of 2019, went into effect in 2020. Of course, like I mentioned, the pandemic, a lot of people were focused on that. A lot of landlords did not get this disclosure out in time. It was supposed to go to all tenants by the middle of 2020, and any new leases going forward are supposed to include this language. This form is from the California Association of Realtors. I've done other content on AB 1482 and this form. This is called a rent cap and just cause addendum. And this has a required language for a landlord to state whether they are exempt or not exempt from the bill. And in the bill, we have rent caps and we have just cause eviction requirements. So that's an important thing for landlords to make sure they get out. And in 2017, this passed, and by 2018, you're supposed to be giving these out. And this is a disclosure about bed bugs. Very exciting stuff. This is supposed to go in all new leases. And what it talks about is how to identify bed bugs and what to do as a tenant if you find bed bugs. Landlords must also disclose if they think there are bed bugs in a property. So this is required as well. Make sure you've got this in your rental agreements and leases. Another one from a few years ago, the tenant flood hazard disclosure. We must, as California landlords, let our tenants know if the property they're renting is in a flood zone and may require special flood insurance, also required for all new rental agreements. And if you have tenants in place from before this was required, you now have to give it to them as well. So make sure all tenants have the required tenant flood hazard language in the rental agreement or on a separate disclosure. An oldie but a goodie, one we can't forget. This is the lead-based paint advisory or disclosure for all buildings that are built before 1978. So 1977 and older, it is required for the sale and lease of any of these buildings that a disclosure like this is given. And we must also give a booklet about lead-based paint. We have language for a landlord to disclose if they know there's lead-based paint. And there's also advice on how a tenant can test for lead-based paint. So this is required for all buildings built before 1978. Another important law to know that went into effect in years past is SB 329. And what this does is prevents landlords from being able to discriminate against those who have housing vouchers, for example, Section 8 vouchers. So a landlord is no longer allowed to simply say that they do not accept housing vouchers, we don't accept Section 8. That is against the law in the state of California. The landlord is still able to run the tenant through a screening process, but can't avoid having the tenant go through the screening process because the source of income is a voucher like Section 8. Diving into 2022 laws, make sure you remember that according to AB 832, which is the most recent of the eviction moratorium legislation bills, according to this legislation, if you're giving a notice to pay or quit, you must also apply for rental assistance as a landlord, and the tenant must apply. And if they don't, then the landlord can move forward with the unlawful detainer. This runs through March of 2022, and the lack of payment of rent does not have to be COVID specific. So any case where a tenant is behind on rent and a 3-day notice to pay or quit is used, they must apply, and the landlord must apply for rental assistance. And again, this is through March 2022. After March 2022, unless something gets extended or changed, we'll go back to the old 3-day notice to pay or quit. SB 732, the Toxic Mold Protection Act, was actually passed a little while ago, but finally the booklet that can be given out, that must be given out, is ready to go. And you'll find this, I have a link below. The California Department of Public Health put this booklet together, and what it talks about is the risks of exposure to mold, and it also discusses what can lead to mold, which is moisture. This is a booklet that must go to all prospective tenants that are moving into a unit. So before you have tenants sign the lease or rental agreement, a California landlord must make sure that the tenant receives this booklet to understand how to protect themselves from toxic mold. AB 838 is related to the enforcement of complaints against housing. And in this new regulation, if a tenant or occupant or an agent of the tenant or occupant has a complaint about the building that they give to the city or county related to substandard living conditions, so health and safety items, or specifically to a belief that there's lead paint in the building, then the city or county has special obligations. The city or county must inspect. They have to document any violations and let the owner and or manager know about the violations. They have to let the owner or manager know the action that's required to remedy the violation, and they have to schedule an appointment to come back to make sure that the situation is taken care of. Additionally, the city or county must give a free copy of the inspection report to the tenant, and there can't be any unreasonable requirements. And they define some of the unreasonable requirements as first having to ask the landlord to remedy the situation, or having to be current on rent in order to make the complaint. So these are changes to the way that violations are reported and responded to by tenants. AB 468 is a bill for emotional support animals. It actually only covers dogs, but there's some important information in this bill, important provisions. If a dog does not have the special training to be a signal, service, or guide dog, it is a misdemeanor to claim that it does. And that also includes putting special vests or tags or certificates that claim that it has the training when it doesn't. So that is a misdemeanor for the owner and a misdemeanor for someone who is selling the dog. Another big change is related to health practitioners and documentation stating that an individual needs an emotional support dog. The new regulations require that this health practitioner be licensed and have a valid license. The healthcare practitioner must have at least a relationship of 30 days before signing the documentation, and they actually have to complete a clinical evaluation to make sure that the individual needs the emotional support dog. AB 468 is not to be construed as changing any existing fair housing regulations related to reasonable accommodation. Let us know what your questions are in the comments below, and if you think we missed any important ones for 2022. Make sure you subscribe to our free weekly email newsletter so that you get these updates and you don't miss anything that's important to you as a tenant or landlord and a buyer or seller. Make sure you check out this next important video on the housing market. Thanks for tuning in. This has been Christian Walsh, real estate agent with Wire Associates, and we appreciate you.